Hello, I'm Rex Hogue. This particular session is what happens on death. Well, the very first thing that I think of is what I call the estate settlement cost funnel. Think about a trip to the store. You have a basket, you get up to the cash register and they scan every item. And if it's a grocery store, they tend to put it in bags, or whatever store, they tend to put it in bags. Well, that's sort of the process that happens on death. Everything a person has to be sorted through and dealt with and put somewhere. So the estate settlement cost funnel, everything a person has goes into the top of that funnel. There are four types of expenses that come out. Now, hopefully, you're able to get a look at this funnel. You can ask us for information about it to kind of follow along, but I literally could spend hours talking about this funnel. Fortunately, I'm not going to do that. But there are four types of expenses that come out. The first are administrative expenses. I have those outlined in green. The reason is you're always going to have administrative expenses. Now, when I look at this funnel, this is what I think of. I first think of which administrative rules apply. Then I think of how many different rules apply. The more rules that come into play, the more expensive and time-consuming it is to deal with that administration. And the third is, where do you put your family in this process? So when I think of the administration part of this that comes out, those three things come to mind, though they come up in other ways. The last three things I have outlined in red, and the reason I've outlined them in red, these things can be largely avoided through good planning. One of them is probate. I will talk about probate a little bit more. The second one is what I call predator expenses. That's either existing creditors or future lawsuit predators. Those can come up. And then there are tax issues. Tax issues can be largely planned for. Now, do make a note of this. If a Form 706 is required to be filed, and the Form 706 is known as the estate tax return. Here in Texas, we don't have a separate state inheritance tax return, but some states do. If you have to file that 706, it's going to be at least 9 months to administer the estate, and it's going to be a lot more expensive. Now, there are four ways that assets pass upon death, and there are only four. So with each asset, let's imagine at the grocery store that we're going to sort stuff and we're going to put it in 4 bags. The first bag is joint with right of survivorship. So when we look at any asset, the first question we have, does it pass jointly with the right of survivorship? If so, it must pass to an individual beneficiary. If it doesn't pass by right of survivorship, the next question we ask, does it have a beneficiary designation or a transfer on death designation? This is going to be on things like life insurance, annuities, retirement plans, certain institutional accounts. I refer to this as planning by the box. Why do I call it that? Well, because there's a little box on a sheet of paper that says, if something happened to you, where do you want this asset to go? And whatever you put in that box, that's going to dictate the rules. Now, if you put an individual's name at the box, it passes directly to that individual, assuming they're still alive. Now, right of survivorship, beneficiary designations, and transfer on death seem very simple. That's deceptive, though. They're actually very complicated. And you can lose complete control of what happens to your assets. They also both will blow any tax planning you may have done. Now I'm going to come back to the box in a couple of minutes, but if it doesn't pass by beneficiary designation or TOD, TOD is short for transfer on death, by the way, then the next question is, was it owned by a trust? If so, it's going to pass according to the trust terms. If it isn't owned by a trust, the only thing left, it's owned by an individual. In that case, it goes through probate, and it's controlled by the will or intestate succession. Intestate succession is the will our state legislature has graciously signed for you, just in case you either don't sign your own will or the will you signed is somehow overturned or not valid or not found or whatever. Now, if you have a trust-based plan, assets that go through probate are typically passed to the trust through what's called a pour-over will. So assets after probate are then passed by the trust, and they're controlled by the terms of the trust. You can also name the trust in the box that I talked about earlier. If you do, then those assets that pass by beneficiary designation or TOD go to the trust, and then they pass according to the trust terms. Now, the last thing you can use the box for is you could name the estate. And if you do that, that means your probate estate. The term estate can mean several different things, as you will learn if you watch enough of these videos. Now, the estate is also the default for the box if other designations in the box fail for some reason. For example, if you name somebody who's predeceased you, then it's going to go through your probate because they're not there to take it. Now, all four of these methods get assets to beneficiaries, but they're not equal in the way they do it. So in thinking about the administrative laws, and remember, go back to the funnel where I talked about what are the administrative laws, now you're going to understand why I say the more administrative rules, the more expensive this is going to be. So there's three things that you always have to look at in an estate administration. You always have to look at case law. You always have to look at banking regulations, and you always have to look at the Internal Revenue Code and the Treasury regulations. Now, right of survivorship, beneficiary designations, and TODs have a common set of rules. And in each state where we have an owner, a survivor, a beneficiary, or where assets are located, we're going to have to follow these particular rules. Now, note that to make these things come into play, we've usually got to have a death certificate, and that can sometimes take a while, especially if there's uncertainty over why someone died. Also note that the Internal Revenue Code has special bad tax rules that apply to right of survivorship, direct beneficiary designations, and TODs. Then there are 4 different statutes that come into play. The estates or the probate code of each state involved, the property code, the insurance code, and the family code. And conceivably, there could be other laws. Now I'm going to give you a case showing how several of those came into play. And I'm going to go ahead and share it with you. It's the story of a lady who came in to see us. Her mother had died. Well, she wanted to probate her mother's will. She was anxious to get it done quickly. So she came to see us on a Monday. Her mother at that point had been dead for 8 days. She brought us the will, and then we gave her a package of information and told her, when you fill this out and bring it back, we'll have it ready to file within 48 hours. I explained to her that there's a 1 o'clock deadline on Thursday. If you get it to the court by 1 o'clock on Thursday, you can be at hearing a whole week sooner than if you file it at 1:01. Now, I was really thinking that she would work on getting it to us for the next week, but when we came in the next morning, Norma was right here, ready with her package. In fact, she was waiting when we opened. Well, when I looked through her package, I discovered that 80% of the assets passed by right of survivorship, beneficiary designations, or TODs. That meant that her mom's will was only going to control 20%. I also noticed that she had two brothers. They had both been previously married, they both had children from the prior marriage, and they both lived in other states. One of the questions we asked was, how did Mom like her new daughters-in-law? And it turned out she didn't care for either one of them. She liked the first daughter-in-law who gave her grandchildren. Now, Norma left, and we told her, we're going to call you Thursday morning and have you come by and sign this application so we can get it to the court. This was before the days of electronic filing. Well, we called Thursday morning and we could not reach Norma. More than a week went by before she called in. And the first thing she said when I got on the phone is, what a difference a day makes. I need to come in and talk to you. So she came in, and here's what happened. She had a brother named Harry. Harry lived in Illinois. Harry had minor children from his prior marriage. He had gotten remarried. On Wednesday morning, Norma got a call that Harry had died of a heart attack 10 days after his mother. She really forgot about trying to get the probate filed and got ready to go make an emergency trip to Illinois for her brother's funeral. Now, that brought up an interesting question. Harry survived for 10 days. What about right of survivorship and beneficiary designations and TODs? Well, those go to Harry. And they're now going to go according to Harry's estate plan. So we asked Norma, did Harry have any kind of a plan? Yes, he did. He had a simple will. We asked, does that mean a simple will that all went to his wife? Yes. So 80% of it's going to go to the new wife that Harry's mother didn't care for. The other 20% is going to go to his kids, and I'm going to explain that only involved two pieces of property, the homestead here and a piece of property up in Wisconsin. And that was going to require a probate here and a probate in Wisconsin, but then those assets after the probate would go to the minor children. Of course, then they're going to have to go through a guardianship in Illinois. And I would submit to you that the lady who died, she lost 100% control of what was going to Harry. Then Norma said, well, that's not all. So here was her brother's story from up in Wisconsin. He got home on Monday. He had a call from the bank that right of survivorship and TODs had paid. He needed to come open a new bank account. So he told them, I will be there tomorrow to open the account. The next morning he got up, and as he was getting ready to leave the house, a process server showed up at his door and delivered him a package. He opened it up and discovered that his wife was suing him for divorce. So he spent the day finding a divorce lawyer. What happened to him the next morning? He got the same call his sister did. His brother had died. So now he has to go to Illinois for a funeral. What do you think he did with the money? Well, if you guessed that he took the time to go to the bank and take an hour or so to open a new account, you would be wrong. He was in a hurry. He wanted to do this quickly, so he took the money and he put it into a joint account with the wife who's now suing him for divorce. Now, I just was very surprised to hear that. That seems incredibly stupid because that gave her the opportunity to withdraw the money. Fortunately, she didn't. However, that meant we had to turn to the family code in Wisconsin to find out what happens to it. And under their law, his wife would be entitled to 1/3 of what he put in there. So we have now seen the probate code in Illinois, the property code in Illinois, the insurance code in Illinois and the family code in Wisconsin come into play regarding mom's estate plan. Now, that case, we showed her about probate, but let me talk about the trust, because we didn't have a chart to show her with a trust at the time, or at least we didn't show her a chart with a trust because her mother didn't have a trust. But if you have a trust, there is one set of rules that you use, and that's the trust code of the applicable trust state, in this case, Texas. Texas trust code and the trust itself are what determine the rules for how things are administered. You may remember that I said the more rules you have, the more expensive it is to administer. Well, a trust allows you to plan using only one set of rules. Now, if it's owned individually, we've got to go through probate in each state where the person owned a real property interest. Now, real estate is simple enough, that's real property, but what about mineral interests? Well, in Texas, they're real property. In some states, they're personal property. So that is a state-by-state determination. Now, let's talk a little bit about probate. Probate is public and court-controlled, but probate is not a problem. Probate is a solution to a problem. The problem is we need a person's signature to transfer their assets. Since dead people can't legally sign stuff, and we don't know how to make that happen, a judge has to prove a substitute signature. That's why probate exists. If that sounds familiar to you, that's the same reason we have guardianship. It's the same reason, it's the same issue dealing with incapacity. We need a person's signature who can't sign. Now, probate is a technical term. It means to prove up the will. So when you call a lawyer's office and you ask them, what does it cost to probate a will? They're going to give you, in all likelihood, the very technical answer. But it's not the answer you're looking for. The layman's definition is, it's the court-supervised transfer of assets for a person who has died. Now that can lead to misunderstandings between law firms and clients, because you asked the law firm a very technical question and they gave you the correct technical answer, but it wasn't the question that you wanted the answer to. Now remember that we go to probate because a person owns assets in their own name. We need their signature to transfer the assets and they can't sign. Everyone can be affected by probate. If a person has any titled assets in their own name, whether it's a small bank account or real estate, stocks, bonds, mutual funds, mineral interests, businesses, they're on their way to probate. Now, I'm going to ask you this question. Is probate a good solution to the problem? I've told you that probate's a solution, it's not the problem. Some people hate probate. Some people love probate. I fall somewhere in the middle. We need probate. Unfortunately, we're going to have probate even in cases where things are well planned, but it can be avoided with good planning most of the time. Now people will ask, does having a will, a valid will, help me avoid probate? The answer is no. Having a will-based plan guarantees that you're going to go through probate, because that will is not valid until it's been probated or proved up in court. Now, I know this is true because people ask us these questions. They ask, how much does probate cost and how long does probate take? Those seem like great questions, but they're the wrong questions. Nobody who's being honest with you can answer either one of those questions. And I'm going to walk you through the reasons why nobody can tell you. So here's a hint. If you call a law firm and they tell you, we charge X amount to probate a will, and they don't explain to you exactly what that means, run away. They will lie to you about other things as well. If you knew, here's the two questions you would ask. Who gets paid first in probate, and who controls the process? Well, our state law tells us the order of payments, and I'm going to go through those quickly. Number one, funeral and last illness up to $15,000 each if the court approves. Now, that little phrase, if the court approves, should concern you. The way courts approve stuff is lawyers go to court and argue them. Lawyers going to court and arguing stuff is expensive. The next one is not actually numbered. It's the family allowance for up to 1 year if there are qualifying family members, and that would include surviving spouse, minor children, and incapacitated adult children. Number two comes the cost of administration. That's our favorite part. You know why? That's where lawyers get paid, along with court costs, executor fees, and then preserving, safekeeping, and managing the estate, and any unpaid guardianship fees. Had a probate case one time where we had been involved in a guardianship, and the guardianship was successfully resisted. But the brother of our client thought he wasn't going to have to pay for those guardianship fees until he realized that a claim was made in probate. And all of a sudden, resisting that probate and running up a bunch of fees cost money. It would have been cheaper to have gone through the guardianship. Then comes secured claims and tax liens. Number four, unpaid child support and interest. That doesn't apply to a whole lot of our clients. Then taxes, penalties, and interest. Did you cheer there? You should have. You know why? That's the IRS. Can you believe the IRS is number 5 on the list under Texas law? Number 6 comes the cost of confinement through the state. If the person who died had been in jail or prison, the state can recover the cost of that confinement through the probate. Number 6 is the repayment of medical assistance if they qualified for Medicaid or something like that. Number 8 is other claims, generally unsecured. Now, almost any creditor would prefer to be higher up on the list. And this seems like a straightforward list, but let me tell you how probate works. The way we handle a probate, one way or the other, every law firm does something like this, a variation on this. We charge a flat fee to take the will to court, prove it's valid, get an executor appointed, help them get what are called letters testamentary so they can start conducting business on behalf of the decedent, and then post a general notice to creditors. We do all of that for a flat fee. Everything else we do by the hour. The inventory is the one other thing that has to be done. But we spend, in some cases, 3/4 of our time dealing with those people on that first 8 things. As they make claims, they have to be dealt with. Nobody can tell you how many claims will be made. Nobody can tell you what it's going to cost to resolve those claims. Nobody can tell you how long it will take. That's why nobody can accurately tell you how much a probate's going to cost and how long it's going to take. We find that probate typically takes 8 to 10 months. But there's a study that actually shows Texas probate lasts up to 16 months. I don't know how accurate that is, but there is a study that backs it up. Now, think about those 8 people. Who is not on that list? Do you know? It's your family. They're not on the list. They come after probate. Do you remember when I talked about the funnel that I asked, where do you put your family in this process? Well, even if probate, and Texas has a good probate system, by the way, but even if you go through an efficient probate system like Texas, your family is still last on the list. Let me give you my definition of probate, and I've asked probate judges about this, and I've yet to have one disagree. probate is a lawsuit you file against yourself at your own expense to protect your disgruntled heirs, your creditors, and your future lawsuit predators. Is that really who you were looking to benefit? Now, I'm not going to talk about probate services, but I will show you these 2 pages that outline the services in probate. 2 pages. It's a lot of potential things that can come up. Now, if you have a trust, there are things that have to be done. A lot of people think, well, you have a trust, there's no reason to administer it. That is not true at all. There is still a probate administration. There's still an estate administration, but with a trust, you can avoid the probate part of it. Now, our trust administration page only is about 1 page long. It's almost exactly 1 page long, or about half as much to do as there is in the typical probate. One thing that I want to address is a lot of times people want to compare administrations. And I've heard people say, well, gee, we probated Dad's will and Mom had a trust, and Mom's trust was more expensive. There are times that could be true. But in a comparable administration, a simple probate is always, in my experience, more expensive than a simple trust administration. A complicated probate is always more expensive than a complicated trust administration. Unfortunately, people get caught up comparing the simple with the complex, and you really can't do that. You've got to compare how difficult was it to administer an estate. That concludes our basic part on what happens on death. There is more that I could say, but this covers the basics. Thank you for taking time to watch.